All right. Hello, everyone. This is Curt.
Brad Pinsky.
All right. And here we are for another edition of Fire Law Roundup, this time for December 19th of 2022, coming toward the end of the year here, Brad. So go ahead. Take us away.
I don't even know how to start. Let's go to Washington. Let's go to DC. And there's a lawsuit. Normally, we don't prejudge the truth of the facts because we don't know. They're just allegations. Here, however, we have an arrest and a conviction, presumably based on what happened. So I'll go. This is a little long, but let me do it anyway. And this is a really interesting and pathetically probably more true than not story. So here we have a female firefighter. She's suing for a couple of things, and I'll go through it. But she's in federal court, and she's suing alleging violations of Title VII and the DC Human Rights Act, which I presume she can do in federal court as a tag-along claim. And she's also suing over retaliation. Frankly, if it was me, I would have added in Family Medical Leave Act, which as well as some other
always
things.
Find a way to work that in there.
We do. But that was the point, that FMLA, for the knowledgeable attorney adds you a lot. So I'll go through the facts, not quickly, just through the facts. So in 2020, she alleges that during a night shift, a lieutenant walked in, walked into her bunk room, and in short says, listen, somebody needs to see you. I didn't totally get this. You're being relieved of duty. But nonetheless, he then sticks his hand, he leaves, comes back a little bit later, sticks his hand down her shirt and grabs her, and then apparently somehow stuck a $20 bill in her.
It's 40 total.
Oh, okay, 40 total. And sticks money in her shirt, bra. I'm not sure. I like that the complaint says she felt uncomfortable. That would be an understatement for me. She expresses to him that she felt uncomfortable. He says he's allegedly said something like, it makes comments back like, oh, you didn't leave this. And he's making these strange comments, but in any event, he gropes her unwantingly. I would say that's assault, if not a battery, but nonetheless, she then complains about it. Now, this, if true, is also extremely shocking because she reports it. She both goes to the police, kudos to her and whoever is advising her, 2 days later or so, but that's not uncommon for people to wait and contemplate rather than run right to the police.
And process what happened, right?
Yeah, and a lot of lawyers like to say, oh, you didn't go for 2 days. That's pretty soon to go to the police. She fills out the police report. She then tells the department. The department, this is a little confusing, sends her to somebody
very confusing, yeah.
Right, maybe wasn't the right person who was supposed to be addressing it, but she was told it was. She reports it, and she reports that she's been sexually harassed. I hope also said and physically abused. And nonetheless, what's striking to me about these allegations is the department says, well, because it's being investigated by the police, we're not getting involved. Mm-hmm. Which I understand that line of thinking. I have said that as part of a long series of other actions we're going to take, like making sure you never see this person. Maybe the charges here are so serious, right, that he should have been relieved of duty. The Grover immediately sent home. Hey, fine, with pay as we investigate. I do understand not conducting a full investigation, but here, right, because the police are investigating, but at least take the darn statement from her. And that's enough to say you're not going to work together. Nonetheless, she asked for 2 days off. This is my FMLA claim. She asked for time off because of the traumatic stress, allegedly. They give her only 2 days. That's why I say that's a violation of Family Medical Leave Act, unquestionably. Nonetheless, she didn't raise that, but she is then forced he's not removed from the firehouse, right? And as we said on the last time, there's no secrets in the firehouse. This is all going around. right? People have allegedly commented that they've heard about it, they know about it, and state everybody's talking about it. And basically nothing really happens for a while. The guy's still working in the firehouse. See my eyes of amazement here. She's encountering him. She continues to say, I'm uncomfortable and don't feel, I fear for my physical safety, she said. At that point, we got a violation of the workplace violence statute, right? And I agree, this is also workplace violence. I would have added so much to this lawsuit, nonetheless, but, and he keeps remaining on duty. That really sums it up, except the big kicker is, I don't get this either. So in June of 22, the lieutenant's convicted of sex abuse in DC Superior Court. He's sentenced to 120 days of incarceration, but of course, nobody goes to jail anymore unless you murder somebody. So the sentence was suspended. The court ordered a $50 fee, and he would be on supervised, I think, in-house or something, probation. I don't know. He was in-house for a little bit, but he's on probation for 12 months.
Yeah.
What I didn't see is, as a result of that, did he lose his job?
We haven't been able to document that. I didn't see anything in there. I would have thought that would have been in the complaint. There was something about 30 days after the incident happened that the department did something, but it was a little ambiguous. But, there's a part of this that we got to wrestle with. We have a little bit of a bureaucracy in bigger fire departments, okay? And she went initially to her company officer. So, I'm assuming it was a lieutenant that she went to. So any supervisor, when they become aware of an allegation of sexual harassment or sexual assault, it's the same as if the fire chief, it's the same as if the mayor, they're a supervisor.
Right.
He apparently did some diligence, but he may have sent her to the wrong person for an EEO complaint. Now, that still doesn't explain why some of the other people that became aware of it didn't send it to the right place. And like, oh, well, we're not going to investigate because you didn't come to the right person, or we're not going to handle this properly. You've got to go talk to. So this isn't like a football that you can hand off to somebody else and now they get to run with it.
Right.
You're aware of it. And now that you're under a duty of due diligence to properly handle it, to properly report it, and it just doesn't look like it was done. Now, this is her allegation. We don't, but
the sentencing gives some credibility to it. But just to add on one thing they said, because it was a lieutenant who allegedly did this to her, DC loses, right? When a supervisor is the harasser, you lose. I don't agree with this rule, but it's the law. The employer is deemed to know what the supervisors do. He's a
supervisor.
And he's a supervisor. They lose. So the only question is, how badly do you want to lose? Had they sent him home, taken care of her, gotten her counseling, and addressed the situation right off the bat, we probably wouldn't have a lawsuit because she wouldn't have felt dismissed and violated and embarrassed, right? If this is true, this was an incredible, incompetent reaction to this. Total failure. Whoever was part of this should be ashamed of themselves if it's all true.
Right. I got a question for you. And I meant to research this myself, but maybe you're familiar with it. Under federal law, under Title VII, you have to make a claim within 180 days, unless your jurisdiction has adopted, some additional parameters, which then it extends out to 300 days. So if we assume that she's got 300 days and she didn't file the EEO complaint properly, because she was misled, that would be sort of one defense. I think that's one. The other one, and I know in many firefighter Bill of Rights states, there's time frames that you have to file charges within so many days for a Bill of Rights disciplinary violation, but they're typically suspended. Those time frames are suspended when there's a possible criminal act, to give the criminal process time. Do you know off the top of your head whether or not the 300-day running for the EEOC complaint is told when there's the possibility of a criminal offense?
I don't know on the criminal. I can answer the first part, which was about her being misled. I don't know on the criminal if it's told. And I just read a number of cases, a little bit different, that when you file a challenge to an administrative action, in New York at least, and went to New York State's highest court, if you failed to raise parallel causes of action at the same time, they would dismiss the ability, right? If you missed it, they would dismiss it because you didn't file both together, and you could have. This is kind of along the same lines. Now let's talk about the first. I think it's a fair question. I think it should toll, but I've not seen it toll for criminal, and I've had a number of these cases on the defense side. What I do believe would toll it, however, is because I was just involved in a case with tolling based on misrepresentations of a, in this case, a fire district, but an agency, a government agency. The courts will toll when you relied on that. When you relied on the statement. So if somebody said, hey, we're filing this for you, or we're taking proper action, and you had a good faith belief, and here's the kicker, the action they said they took would have had to delay, right, your ability to file, or would have had to give you extra time. Frankly, as long as they're investigating, it's told, right? The statute doesn't, or the time to file doesn't run because nothing bad or good has happened to you yet. You haven't been discriminated against because they haven't said you lose. I mean, once they render a final decision. So what I'm looking for is, when does it start to accrue? When did she receive a decision that would start the 300 days? Just from what we have at the moment, I couldn't.
Well, no, it starts the day that she was assaulted. That's when the 300 days starts.
I'm not so sure that it's because the allegation she's claiming is not just that she's assaulted. It's that nothing happened to cure it.
That can be this. That's the retaliation, and that's got a separate. Right. Each of those acts could potentially have a separate 300-day total. But this is different too. And you think about, for example, let me use my own fire department, the Providence Fire Department. If someone filed a complaint, it's not going to be filed with the city of Providence. It's going to be filed with the Rhode Island Human Relations Commission or the EEOC,
right? Because
they are the appropriate party. In the District of Columbia, is the appropriate party because it's not right. You think about it. So that complicates this, and you could almost argue that complaint to that initial lieutenant was the equivalent of an EEOC complaint. Now, I don't know enough about the ins and outs of the administrative procedure in DC, right. But there's an awful lot, to chew on here in this case to think about. And
and one of the things we should highlight or repeat, because we've said it, right? If people are looking for the lessons in these, these things go right to the top, right?
Absolutely.
You don't leave them with another lieutenant or a cap. Come on, right? You're talking about sexual assault resulting in a police matter. But look, you've got workplace violence issues. You got family medical leave and post-traumatic stress issues. You've got all sorts of different issues that have gone on. And if you don't get this to the highest level and make sure it's being taken care of at the highest level, it's not going to go well for you. So that's how you don't react like this, right? Allegedly, right? On these alleged and
tough situation. But again, just to kind of go through the bureaucracy here, it looks like there was some confusion between a line officer being notified, and then apparently internal affairs got notified. But both of those are separate from an EEOC complaint,
right?
And really, I think what is important in this case is that the EEOC complaint gets filed as well, because that's the one that's got to be filed within 300 days in order to protect or preserve those Title VII rights.
Right. And agree. She's got all sorts of other avenues if on the underlying assault, right, there's not sufficient action. I think she could get around it different ways. I have a hard time believing a judge is not going to side with them, saying, listen, you were greatly misled by what was happening here. I don't understand that, the EEO person not being the right person. How do you take a statement and be like, what am I doing here? Right?
If I'm an internal affairs investigator or in charge of internal affairs, and somebody comes to me with those claims, I'm not just going to keep it. I've got to advance those to the proper people. I mean, that's
right. And one other thing I should mention, you will never go wrong. Look, you and I draft policies that outline your rights and remedies for everything, including sexual harassment, all right, and sexual assaults, any sexual inappropriate behavior. Mm-hmm. The best thing anyone can do, in addition to investigating everything else, is hand them your policy, which hopefully outlines all of their rights. So you can say, what did I advise them? I advised them, here's the policy, as opposed to you, a lieutenant or whoever, interpreting what you think should be said and what rights there are and maybe not covering. Hand them the darn policy, right? Much easier. Oh, well.
Good point. What's next?
What's next? Let's go. This is easier, but it's kind of humorous in some sense. Let's go to Somerville, Mass, place I know pretty well. Here, so an individual, a female who's a veteran of the military. I'm not going to say decorated, but she's definitely been sent to some hostile places. She applied for and was denied a position as a reserve firefighter in Somerville, Virginia. Can you explain? I'm not familiar with that term, reserve firefighter. Is that like
I'm not either. No, it's not a normal thing, but again, I'm not sure that just means they're not assigned to a shift and or they're per diem, or I'm not sure what it means. So, but that's what they said in the complaint or in the decision. It was reserve firefighter. So I left that end alone.
Okay, so her allegation here, and I'll give you some of the facts. I thought the administrative agency did a good job. The commission did a good job, but she was denied the position. It was given to someone else, a male, I believe. And she alleged that she's being discriminated against because there's a bias against veterans, which you better be careful who you make that claim against, as we see in a moment. And she said there's no reasonable basis for their decision. So what happens here is she filled out an application and constantly didn't answer or gave vague or non-responsive answers. And the commission says, there's so much of this that there's far too much to overlook. This wasn't like one, you didn't answer fully. And when she was asked for clarification, she gave really vague, strange answers, right? And I thought one of them was kind of interesting. So there was a series of questions that pertained whether you were in a previous, if you were in a previous public safety position, and whether she's been investigated for excessive force, right? Which makes sense. You might, as we get to Miami, that's probably a good question.
Yeah, and especially if the same questions are asked of police officers as well,
which probably is right. And again, as we're going to see shortly in Miami, or Florida, it's probably a good question, but nonetheless. And she says in response to, have you ever been investigated or involved in, an incident for excessive force? She says, well, something like, a crane operating at a construction site, that's a public safety position, and failure to properly handle the crane could result in excessive force if it hits something. At this point, you're thinking this individual is either crazy or hiding something.
Yeah, she gave that during her oral interview, as I understand it.
Yeah.
So
weird, right? I mean, just weird. So she failed to answer several questions. She failed to talk about discipline. They found that she was not being forthcoming and truthful when she was asked if she ever was disciplined, because she found she was put on academic probation at a college. She came up with an excuse for why she was on academic probation, saying, I was working this other job. But then they found that wasn't actually true, because she wasn't working the other job at that time. So in short, the commission held, because she was not forthcoming and not overly truthful, they found the department was correct in not hiring and passing her up.
Mhm.
Now, there was one more interesting thing. She claimed there was bias against veterans. I don't even know where you'd come out with that based on what happened, but nonetheless, the assistant chief who's on the hiring panel is a veteran himself. So that's kind of like alleging Clarence Thomas is a racist, which people have done. Nonetheless, that's it. I think the lesson to me in this is, if you have there must have been a good record kept here, and write good notes as to her answers to oral questions and interview questions. And obviously they kept her application, and they did pretty good background check. Somebody, whether it's the commissioner or the department, one of them did pretty good background checks on her to find out some of her statements were not true. If you are right, this is the point. Don't worry about being accused of things. Don't worry about being sued. Don't worry about somebody fighting it, right? Because that's what certain people do. You can't stop that. Everyone thinks they're right and nobody else is, everyone else is to blame. But if you have good facts and you have good documentation of those facts, stand your ground, which is what they did, and they were right here.
Yeah, that's why I like to include cases like this for that very reason, because it's sort of a blueprint for what sort of documentation is a department going to be required to maintain in order to prevail in a case like this. And it's a sort of a textbook example of when you decide you've got somebody who's number one or next on the list and you're going to bypass them. What sort of documentation do you need? Here's the blueprint.
Yep. And, we've seen the opposite. We've seen cases like, well, you're female and there's so many males here. We don't want to put you in that position, so we're not going to promote you, or, stupid things like that. But that's not what this is, right? I mean, this is a well-documented case. So I think all good here. Okay, very quickly. Look, we have two more things to go through, both very quick, if not one of them being humorous, but not this one. In Florida, we have a firefighter who's accused of payroll fraud. Everybody should be very careful about this. Even in my own city, I'll go through the facts, but we had a very upstanding individual. He was the public information officer for the city of Syracuse, and the guy was just knew everybody. I met him twice and he remembered my name both times. I mean, the guy's right on. If there was a murder, if there was an incident, he's on the news. And he was convicted of this type of thing. People call it stealing time. But here's what happened. And then I'm going to talk about that too. He was accused of just putting in, having worked 3 24-hour shifts that he didn't actually work. They caught it. He entered the time himself. They caught it. It would have resulted in just under $1,300 of increased payroll. But he was then, fired. And they said, he not only stole money from Polk Fire Rescue, he stole taxpayers' money. That was the quote. And they say, in addition, he embarrassed his colleagues who risked their lives for this community. He resigned, but he's being charged. So this is not good. This is theft of time. So this comes up in less subtle ways. This is where I was going with the city of Syracuse. Usually what this happens is somebody's working another job, is still getting paid at one job, and is working somewhere else and gets paid for both. And right. And you can't do that in public service. Even if you're salaried, I caution people, you better go check with somebody. If I'm salaried as a fire chief or whatever, and I have a separate construction job or something, you better make sure that that's not going to be seen as stealing time. That's the kind of informal way people refer to this. This one was way more blatant. I've not seen people just put in time they've never worked. This was just blatant.
We don't see that. You're right. And then there was another case that was referenced. If you go through to the original article on it, there was another case where another firefighter had done something, wasn't exactly the same, but they've had another problem there. Polk County has had a number of problems over the years. And I was down there a few years ago. Seems like a well-run department. And certainly Grady Judge, I mean, he's a legend. the sheriff down there. But you know, I went down to their facility down there. They got a great facility, great auditorium, and I tried to get in to see Grady Judge, as a matter of fact, but he didn't have time. But
He's giving news interviews about it.
But they've had a number of problems, and I think everybody's struggling to hire, you know, and I think that I don't know what that has to do with if it had a factor in the DC case as well, but everybody's struggling to hire people, and you know, maybe we're hanging on to some people. We're first of all hiring people maybe that we shouldn't, and then hanging on to people that maybe we shouldn't as well. So,
but you know, this is tough. I mean, this isn't probably going to come up on a background check. And listen, I have a saying. I just want to say this just to give a little understanding. And I'm not saying this is or isn't what happened, but I have a saying that bad times make good people do bad things.
Yeah.
For all we know, there was a good reason he felt that he had to commit this alleged crime, and he just needed the money and felt like he didn't have another way out. And I'm not making excuses, but a lot of times the people you trust are exactly the ones who steal from you, because if you didn't trust them, you wouldn't allow them to steal from you. You would treat them like you didn't trust them. And if I was a treasurer, I always tell people, treat me like you don't trust me. And that way you'll have proper oversight. You'll review my bills, etc. It's always the people who you trust. Oh, I didn't see that coming. Of course. And that's why you gave them such freedom. But what you have to remember is good people do bad things in bad times because they don't see another way out. You can't allow them to have that. Now, kudos to the department, by the way. They caught it before they actually paid it. So that I think they paid 2 of them. Oh, I thought they said they caught it.
They paid 3 of them, I think, and they caught him on the 4th one, I believe, or the 3rd one. Yeah. So he did September 13th, October 22nd, November 21st, and they caught him when he tried to do it again on November 30th. So, and you know, and thieves usually steal the same way, because they think it worked and you won't catch on to it. Yeah. So
anyway, but you know, bad times. And we're in bad times. We're in a recession, and maybe I'm not excusing it by any means. What I'm saying is you got to watch out for this. When I was chief, we always reviewed payroll. It came to me, I reviewed it. We made sure it was accurate, and, you know, we checked it. They, at some point, did the same thing. It shouldn't have made it past the first time, apparently, but at least they caught it, I guess, eventually. Yep. Okay, let's end on a not humorous thing.
Well, we got 2 more because we still have the New York Firefighter bill.
Oh, right? Okay. So we'll finish the last case.
Yeah.
But the Miami, let's go to Miami. If you haven't watch the video because it does a better job than I'm going to do. But I'll explain the video for the 2 people in America who haven't watched this, who are firefighters. You see this hulk of a male, right? His arms are bigger than my legs. Right? And both of my legs together. He's a big male. And he's a firefighter / EMT, I'm guessing. And they're in a ER waiting room, which is all on camera. And I think this is an ER waiting room where it is. And there's a cop there, a smaller female cop, who is literally the size of one of this guy's legs. But he is standing over on the writing desk about 5 feet away from a patient who's handcuffed to a stretcher, who's alert and conscious, at least conscious. I guess I can't say alert, but he looks alert. And he's done cocaine and something else, heroin, he alleges, I think. In any event, he's under arrest. And the way it reads is not, when you read different news reports, is not the impression you get when you watch the video. It makes it worse when you watch the video, because it looks as if, and I take word for it, the patient spit about 4 feet away towards the back of this male. From what I see, the firefighter is facing the other way. It doesn't look like he's wearing glasses also, so it doesn't look like he spit on his face or anything like that. Plus, it's pretty far away. I mean, he's 4 or 5 feet away. In any event, the guy turns his back towards him, where you can now see how big the firefighter is, and starts pounding on the guy so much where the stretcher's moving, and you've got this female cop, very petite female police officer, trying to hold on to one of his arms and hold him back. It's not working. I suggest it would take everybody on scene to hold this guy back. And he's just pounding the person on the stretcher. So that's what happens. He then he's fired, right? As a result of this.
Oh, was he fired?
I thought he was fired. I thought one of the news things says he's fired.
No, I don't think so. I think he's been suspended.
Oh, okay.
He was, I'm not even sure it was suspended. He was put on administrative leave. And then when the video was finally released, it looks like NBC Miami interviewed him, and apparently he doubled down on it.
Yeah, which was
he didn't express regret. He didn't say, "Well, I was just upset." Quoting from him, speaking about the patient, he said, "If he never knew the consequences of spitting in a grown man's face, then consider my actions public education, and this video a PSA."
Yeah, not a good comment.
So, especially when you're looking at a civil rights lawsuit, you have someone who is handcuffed, is in custody, that the government has a responsibility to protect from this. Although
two different agencies, it'll be very interesting, right?
It's still is government, it's still, you know what I'm saying? And, this could end up in a civil rights lawsuit. The lieutenant could be charged criminally with violating the patient's civil rights.
Frankly, he should be.
He could be charged with state law assault and battery charges, etc. Not that the patient can't be. The patient can be charged as well. And the patient should be charged with battery for spitting on him. But it's possible.
But there's no defense. It's not like I'm defending myself.
It's not self-defense. It's retribution. It's retaliation.
And that's the problem with this comment. He just admits his intent to teach him a lesson.
Ill-advised, very ill-advised. This is where, because person A assaults person B, person B can defend themselves. There's nothing that, you can't defend yourself, but person B does not now have license to hit person A. And it's possible in situations that both of them could be charged with assault and battery.
And there's a cop right there. All he had to say is, I want him arrested, or added that charge on as well. Yeah. He didn't, you don't need to assault our patients who, again, he's maybe drug induced, but he's homeless. So this just doesn't sit well.
Not good.
Doesn't sit well. The only thing I could say, fortunately, in this day and age, is the race mixture was in the right proportion, right? Otherwise there could have been race claims as made. So it was a black male firefighter to a white male patient, but at least you avoid some race claims. Any event, so and there's more background on the firefighter though that you have, isn't there?
He was sort of at the center of a racially charged incident where firefighters allegedly drew phallic symbols on some personal pictures that he had left out, and he left or someone left a noose in the area, and a total of 6 firefighters were terminated in the aftermath of that incident. And now I understand some of them may have gotten their job back, and I don't have all of the details on that, but very, very high profile allegations that really sent some ripples across the fire service in Florida, and particularly Miami. And here, same person now is sort of at ground zero on this one. And
right, which is unfortunate because it undermines, a lot. But I wish he said he was sorry. I wish he said I just had. I
wish whether it's his union or an attorney had spoken to him and say, you really do, even though you're thinking it, that is not what you want to be saying publicly. So unfortunate. Yeah.
So the last one we have on the blog was about a new law, and actually, just so you know, the governor's signing. This is signing period. I just had 2 or 3 laws that I helped write got passed. or signed by the governor this week. We're still waiting. I keep looking to see Caroline's law, the anti-photography that hadn't been signed as of last week. I'll check again. But there's a lot of good laws being added, some bad laws, some unconstitutional laws, I'm sure. But one, I think good law, I think you gave proper kudos, is a pseudo Firefighters Bill of Rights in New York State. So we're talking New York State now. More problems coming from the language, because I read the law now. It takes effect in March, and I've got a lot of questions about it, which I don't think are clear. I'll give you my thought, but it says anytime a paid firefighter other than one in the city of New York, who is represented by a union, they have to have a hearing officer anytime there is a disciplinary matter that could result in suspension or termination. Now, that's how I say it, is how I interpret it. It could be read that any disciplinary matter, and there are a number of cases, and again, I haven't gotten so far into this yet, I just haven't had time, it's very new, but there's a number of cases that talk about what is and isn't discipline, right? Is a verbal warning discipline? Is a written confirmation of a verbal warning discipline? Is written discipline, just documenting that I counseled you, is that discipline? Is something that comes out of your file discipline? And in New York, cases go both ways on these. It's very troubling for me because and it's going to be a problem here because the civil service law and the volunteer firefighters law are modeled after the same law, 75, the civil service law. The civil service law, a lot of courts have said, look, a note in your file, that is discipline. And just as many courts have said, a note in your file is not discipline. I disagree with that.
Well, let me ask you this. Can't Fire Department A say that anything above a written reprimand is discipline, anything below that is not? Can't Fire Department A say that? Fire Department B says we consider anything in writing to be discipline. Isn't that something that could, or does it have to be a state court that says that? Or can't an employer define what discipline is for themselves?
Well, I think an employer can make it more broad, but I don't think they can make it narrow. And that's where the courts have gotten involved. And again, your courts go two totally separate ways on this.
Yeah, no, I got you, but I'm just wondering, like sometimes when we start really looking into it, we realize it's not the courts being inconsistent. What they're saying is this particular employer considers this to be discipline. This particular employee considers like a counseling report not to be discipline.
I think the critical test, and I've seen this in at least one or two of the cases, I think the critical test is, will that be used in future disciplinary hearings? So you have 3 verbals or 2 writtens.
Well, almost anything could be used in a future. If I give somebody a warning, don't, every morning I want you to check the fuel, and that's a verbal warning. I mean, I'm just saying, hey, that could come back if you don't do it again,
Right. And some courts, the ones I agree with, have said, listen, that's going to impact your veracity at trial. It's going to impact the discipline itself, whether you're guilty or not. And it's certainly going to impact the punishment having, right? But the problem is, you didn't get a hearing for that. So here the language uses very broad terms, discipline. So it would appear, and this is why I'm not yet convinced this is where they meant to go. It would appear that even for a verbal warning, if it goes in the file and can be used in the future, it would appear, if you just read the language quickly, that any discipline that could lead to suspension or termination, you're going to need a hearing officer for a verbal warning. Now, here's the problem. That is super expensive, right? I mean, there was an article in the paper, I think they're not saying, an average hearing officer costs $1,500. Well, not a good hearing officer. You and I are going to be significant multiples of that, 3 times of that. Maybe 4,000 or 5,000 for a hearing officer who has significant experience, understands the environment, is not biased. We don't care. And by the way, anyone listening, Curt and I will do these either in person, probably would be more me, but online where these could be done, could be Curt or I. And, these are, but having it done for a verbal warning or a written reprimand is going to be very expensive and unreasonable.
Yeah.
And I don't know who it benefits. You know, you got to use, right? We talk about cost splitting, et cetera, but this is a lot of money. Even if it was $1,000, think how many verbal warnings and written, you know, okay, I'm just going to stick a note in your file. All right. When I was chief, I negotiated with the union. We said, listen, we'll stick a note in your file, but if nothing happens for 6 months or a year, it comes out. Well, wait a minute. But and there's no hearing for that. But if something did happen in 6 months or a year, now you've given up a hearing. You basically admit guilt because you never challenged what happened. And now weighing on the union and weighing on the municipality is it worth a couple $1,000 to go after or defend? And, you know, especially these smaller unions may not be able to afford this, whereas the municipality has the resources. So I'm not a fan of the law as it's written, but in fairness to everybody, I got some more reading to do and try to see how it juxtaposes with some cases, but I'm really curious what they mean by discipline. You know, the other thing it does, which is totally right, and I was a little surprised, is it makes discipline a mandatory subject of negotiation. But I always thought it was. I mean, apparently not in New York.
I think it is in most jurisdictions. I'm not sure what the legislative or the case law in New York is, but most states that have collective bargaining would consider not discipline in a given case, but discipline process, like what's the procedure, that would be a mandatory subject for bargaining. But I'm going to tell you, I didn't think you were going to pick up on the discipline question mark. I thought you were going to pick up more on the independent hearing officer, because that's an interesting issue. Because I'll tell you, you know, I look back at my old department, Providence, and from what I understand, they have a thing called a trial board, which if you're going to be terminated, you got to go before a trial board, and it consists of the commissioner of public safety, the head of HR, and one of the municipal court judges, and a 3-person panel. And from what I understand, from a number of reliable sources, that has become nothing more than a rubber stamp to terminate people, that if you go that process. And I think that's not how it was intended. And I think that municipalities that have that kind of a process it's really doing a disservice to your people. And some people will use it as a weapon. But pretty clearly, one response to that kind of a process would be to have an independent hearing officer. And that's what the legislature in New York. So I'm assuming that there may have been other communities that have followed along that path and had created a system where if the chief, or in Providence it's the commissioner says you're guilty, you know, you're going to be fired. That's it. And
and
you're not getting a fair hearing.
Right. I sent you actually a hearing, wasn't a trial, a hearing I just won, defending a volunteer firefighter. And that hearing officer had no knowledge of the fire service. So we were trying to educate him throughout the entire process of, okay, well, what is chain of command, and who's in charge on a truck, and can you hand off orders for somebody? Right. It was difficult. So but first, you know, when you hire someone, we didn't, as the accused, we don't get a say in it. Right. That I do like this. It's like arbitration, right? It's like union arbitration. You submit 2 names, another 2 names, you come to an agreement. So I like the independent, and it's not just the municipality hiring someone. I think that's important. But you know what? Just to our viewers, if you're watching this, you know, Curt and I propose, and we have one other attorney as well. We got a slate of 3 of us. You can choose that, you know, certainly more by video or in person will arrange, but for people who want a neutral hearing officer, because we don't care about anything other than what's the truth of the matter and what's the appropriate discipline to recommend. You know, there's good ways to get, you know, independent hearing officers. We're 2 of them. The other part I'm not sure, and maybe I haven't paid close enough attention in the law is it a recommendation from the hearing officer that's then adopted or not adopted?
Oh, I think it's definitive. I think.
Or is it definitive? Yeah, I got the impression it's definitive, but I haven't gotten that in the weeds with it because normally a hearing officer under the processes that existed prior to this, if you choose a hearing officer, it is a recommendation and not binding. If this is binding, as it should be, then, right, the findings of fact are binding. Then my next question is, okay, what is the review of the hearing officer's decision? Is it de novo, where the court will review all the facts anew? That's what de novo means for our viewers. Or will they say, listen, we found that the hearing officer was in the best position to observe and determine the credibility, and we adopt, as a matter of law, we adopt his factual basis, and we're only going to rule on legal issues, not factual issues. I wasn't sure if that was addressed. And that is good.
Yeah. There should be an appeal. But obviously, there's always a due process appeal. So you have the right to make sure that it wasn't arbitrary, capricious, and that the person's due process rights weren't violated. But beyond that, boy, it would, to me, when I hear de novo review in court, it's almost like, why go through the sham of a hearing if it's all going to have to come up again in court? So but exactly. that should definitely. But I do want to point out, though, that New York went in a different direction than any other state has gone when it comes to firefighter Bill of Rights. If you look at all of the Bill of Rights that I'm aware of, none of them get into the procedure. They all talk about, what's the right of an accused firefighter when it comes to notice of their interview, what limits are put on the behavior of the investigators during the interrogation, how long can the interrogation be, how many people can ask questions, what about threats or promises, and all those things. So most of the Bill of Rights, every other Bill of Rights that I've seen, have gone in that direction. New York went, in sort of a different direction. And again, I don't know the historical background of what led them, but I can tell you that, and I know there's other departments, there's a couple in Texas, same thing, where their process has just become a rubber stamp. There's no point. And this kind of a law is the outcome when an organization has a disciplined process that isn't perceived as being fair. The firefighters are going to go to the legislature, and they're going to get a law like this, or at least try to get a law like this enacted.
Yeah, and let me on that note, on January 5th at starting at 9:30 or 10 a.m., I will be arguing this exact case in front of the 2nd Department Appellate Division. I may regret letting people know to watch that, but they are all streamed.
Is it televised?
Yeah, it is.
Oh, maybe Fire Law will run it live.
I'll send you the link. But it's important. The facts, the small portion of the facts are this, and this kind of goes against the background. Now, this is a volunteer firefighter, but doesn't matter because the same things happen. A board of fire commissioners of a fire district, the governing board of the municipality, had caused an investigation to be made. And they get the report of the investigation, and at a public meeting and placed in the minutes, they say, we think they're guilty. Now, no hearing had happened. They just say, we think they're guilty. And they put that in the minutes. And then they say, yeah, exactly. I hope the judges react the same way. And then they say, so what we're doing is we're removing somebody from office permanently. We're suspending some others for 6 months, and others for 4 months, and others are suspended, but they're going to get kicked out, right? So all of that. And then I get involved, and I said, hey, guys, we have this little thing called the law, and you can't do any of that. And they, 4 months later, they finally serve notice of charges. 4 months later, right? They finally serve notice of charges, finally say, we're going to give you a hearing. So I said, wait a minute, no point to a hearing, because all the hearing officer does is recommend to the Board of Fire Commissioners, who have already drawn themselves in the corner. They took a public stance, which you can't do, right? Constitutional violation of due process. They prejudged the issue. They took a public stance, put it in their minutes, and they imposed what I say is long-term and permanent punishment. They removed somebody from office as a captain. They removed them, and they suspended people for 4 months, 6 months, or, pending termination. And they just claimed, well, that was temporary. We're allowed to do that. 4 months is not temporary. Permanent office is not temporary. But they then have a hearing right? We didn't go.
Before
We said,
themselves?
what's that?
Before a hearing before themselves?
A hearing before a hearing officer, which they hired, right, to make a recommendation back to them about whether what they did was right, basically. Should the people have been suspended? Well, what do you think you're going to say?
I think there's something about Roger Goodell doing something like that. I don't know, with a guy named Tom Brady. But
yeah, exactly. And this is a case we're going to talk about. And the courts, right? And the courts say in that case said you cannot send it back to the same board. Once you've prejudged the issue, you're done. It's over. So we didn't attend. This was before that, but we didn't attend. This is 4 years ago or so. We didn't attend, saying, look, what's the point of going to a hearing? Right? We can't get a fair hearing. And who's it going to go to? They've already prejudged the issue. So this comes up on January 5th. This is going to be a landmark case, because if I lose, if me and my 5 clients, if we lose, then you will be able to suspend somebody, remove somebody from office for 4 months without even telling them what their charges are, what their rights are, what they did wrong, right? And you can prejudge the issue. You can get involved in the investigation. You can, right? I mean, constitutional due process will be turned on its head if this is allowed to stand. But if it's overturned, as it should be, then, right,
they've got to do it right.
Then we'll get it right, and people will finally start going in the right direction. But all of those issues are why I question some of the things here. What's the role of the hearing officer, right? Binding or recommendation? Is it neutral? Is it not? What's the process? All of this is critical. Discipline is so important. You talk about investigations that, we start investigations assuming guilt all the time, and we shouldn't. And all of that discipline, and I will tell everybody, certainly inside New York, I do a lot of discipline stuff, but if you haven't attended Curt's discipline, course, you're missing something, because these are serious violations of due process, and you've got to properly investigate and discipline. New York is just trying to codify some of that. And, but go take Curt's course on discipline.
No,
and investigations.
I appreciate that. And, it's going to help your organization. If you can do it right and not misuse your disciplinary power, then your organization is going to run better. People are going to trust the process, and you're going to end up with a better culture. But be that as it may. So,
well, that's our week.
All right. Well, that's it. And we'll see everyone after the holiday. We'll follow up. And I think Brad and I are going to try to do some special things, maybe not for right after Christmas, but certainly after the new year. We're going to try to, kind of summarize the year, give you some of the top cases over the year, some of the most important cases, some of the maybe craziest cases. So
when a stripper gets out of your fire engine, that's where I'm starting.
It's kind of hard to top that one, but we'll see what the brothers and sisters have provided for us over the last year. So, all right. So happy holidays.